Ametewee V The Republic, 1994 Ghana Law Report 551. This case is under the Criminal Law of Ghana, and the case is based on murder, intent, transferred intent, specifically Section 11.5 of Act 29. The facts. The appellant, a police officer who was on duty at the Flagstaff House, fired 3 shots at President Nkrumah. One of the shots hit and killed the bodyguard of the president. A pathologist's report confirmed that the deceased died from bullet wounds. Although the appellant admitted firing 3 shots at the material time, he denied that it was any of his shots which killed the deceased. He was found guilty of murder by the jury and was sentenced to death. On appeal, it was argued on his behalf, that although the appellant fired at the president, it would be irrational and illogical to suggest that he killed the deceased, and it was also contended that since there were conflicts in the evidence of the prosecution witnesses which created doubt in the case for the prosecution, the benefit of that doubt should have been given to the appellant. The court held, dismissing the appeal, that 1. The preponderance of evidence showed that only 3 shots were fired, and the pathologist's report also established that the deceased died as a result of an injury he received from a bullet. The chain of circumstantial evidence therefore pointed to the one and only irresistible conclusion that the appellant was the person who killed the deceased. Even if the appellant's bullet killed the deceased by mistake, he was still guilty of murder because if a person feloniously fires at another and the circumstances are such as would make that killing murder, but accidentally the shot hits and kills a third person who was not intended, that is still murder. The conflicts in the evidence of the prosecution witnesses complained of by the appellant's counsel were not germane to the crucial issue which the jury had to determine. Moreover, since the jury were amply directed on the conflict and they still believed the witnesses because there was evidence upon which they could so act, the appellant's court could not upset their finding.